I'm attorney Eric Lewis with Lewis Legal Services in Indianapolis. Today we're talking about filing bankruptcy to recover a vehicle that's been repossessed. In fact, this video is an update to the previous video titled Give Me My Car Back because, well, it's now out of date given a new court decision that just came down this past week. So before we get started, I always start with a disclaimer that this video is not to be construed as legal advice and is only intended for Indiana residents, tailored to the application of bankruptcy in Indiana courts utilizing Indiana law. Okay, that out of the way, one of the most powerful tools for somebody filing bankruptcy is the automatic stay provided by Section 362 of the Bankruptcy Code. It's automatic because it goes into immediate effect, in most cases, as soon as the bankruptcy proceeding is opened in court. For the debtor who filed bankruptcy, the automatic stay stops your creditors from contacting you, sending you statements, calling you, suing you, making you come to court. It can stop the sale of a home in a foreclosure sale. And until last week, we had long operated under the understanding that filing bankruptcy and the automatic stay meant the immediate giving back of a vehicle that was repossessed by a creditor. So your car gets repossessed, and before it's sold at auction, you file bankruptcy. The car gets released back to you without having to immediately pay the fees that are usually demanded, for towing, storage, missed payments, etc. And last week, the United States Supreme Court said, hold up, not so fast. The Supreme Court issued a unanimous decision that said the automatic stay isn't so automatic when it comes to a creditor's obligation to turn over repossessed collateral. The automatic stay's prohibition of exercising control over property doesn't include property already repossessed without anything else happening. Now, as we'll soon discuss, this doesn't mean that filing bankruptcy won't get your car back, but it's now a much more uphill battle. Potentially more expensive, definitely more time consuming, and perhaps the biggest problem, the time it will take to get the car back. The case is City of Chicago versus Fulton. So how did this happen? And why do we here in Indiana care about a case out of Chicago? Well, we care now that the Supreme Court has ruled on it because the law is set across the entire land, across the United States. So what happened? Well, Chicago, like a lot of big cities, loves to give out tickets. Tickets for everything. Parking, speeding, red light cameras. And they love their fees and licenses. For example, for the privilege of owning and operating a vehicle in the city of Chicago, you have to obtain a sticker that you put in the windshield every year for about $90. So on top of your regular license plate registration, you pay another $90 every year. So as you might expect, people in financial trouble find themselves in a position where they can't get their cars back from impound, or they have been impounded by the city for overdue fees. And of course, it's a vicious cycle because if they impound your car, you can't get to work. If you can't get to work, you can't make money. So anyway, the case was actually three different for the purposes of appeal, it was consolidated, and but all three of the cases had the same problem. The city of Chicago impounded their cars for overdue fees. The people in turn filed bankruptcy, expecting to get their cars back without a lot of hassle, and the city fought them. And the fees they owed were substantial. They weren't $50 here or there. I think in one case the guy owed something like $12,000. The other, it was like $5,000 and some change, and the worst one was over $17,000. And remember, you can't discharge traffic tickets and fines in a Chapter 7, but you can in a Chapter 13 bankruptcy proceeding. So in Fulton, the judge, and these were all Chapter 13 cases, the judge in the bankruptcy court agreed that the city had to give the cars back to the people as soon as they filed the bankruptcy. A no-brainer, right? The issue had been long settled since the Thompson versus GMAC case that came out in 2009. The Thompson case told us that property seized before the filing of a bankruptcy must be returned to the debtor before the creditor could assert any right to adequate protection or liquidation of the collateral. which is in this case a car. So back to Fulton. So the city appealed. The 7th Circuit Court of Appeals, which is also in Chicago, agreed with the bankruptcy court judge and said give them the cars back. So the city of Chicago appealed again, all the way to the United States Supreme Court, which said no, the automatic stay doesn't apply to a creditor, in this case the city of Chicago, that's just passively retaining their property. So they're not doing anything further in terms of exercising possession. They've already got the vehicle. So the stay would stop a creditor from repossessing a vehicle after the bankruptcy has been filed for sure. But just having someone's car at the time of filing the bankruptcy was not enough to trigger any requirement under the stay that the debtor be put in immediate possession of the collateral, again, in this case, a car. Instead, there's another provision of the Bankruptcy Code, Section 542, which has to do with turnover of property. I'm not going to get into all the legalese of what these provisions say because this channel is for a mixed audience, but in a nutshell, the rule now is that if you want the car back, you have to file an adversary proceeding pursuant to Section 542 of the Bankruptcy Code demanding turnover. And an adversary proceeding is like a lawsuit within the main bankruptcy proceeding, but it's directed at one particular creditor. The problem for debtors now is that if you have to file an adversary proceeding, it's going to take time to get the car back. And time is not your friend when you need a ride to work or doctor's appointments and so on. So before courts in our federal circuit held that holding on to a repossessed vehicle was itself an exercise in violation of the automatic stay, and the repo man would have to give the car back, and then the creditor could go to court and get its day in court for adequate protection and whatnot. But the approach was always shoot first, ask questions later. Now that's been flipped. No doubt, even if a bankruptcy judge allows the turnover action to proceed by motion practice rather than a full-blown adversary proceeding as the current rules require, it's going to take extra time. Definitely more work and expense for the debtor's lawyer, which will likely result in debtors themselves having to fork over more money at the beginning of their case if turnover action is being contemplated. Although it was a unanimous decision, Justice Sotomayor wrote a separate concurring opinion indicating that she agreed with the result, but was concerned about the resulting complications this would have on bankruptcy filers. So all that stuff you've read online about creditors having to give back your car immediately after you file bankruptcy, throw it away. It's garbage, old news. You want your car back, you can still file bankruptcy to do so, particularly a Chapter 13 setting, but you have to prove you have insurance and can make payment of adequate protection to get it back from the repo man. And you'll probably have to be able to make some kind of payment in a hurry to demonstrate to the creditor that they're adequately protected if they give you the car back. So the moral of the story from Fulton is mere passive retention of property is not in itself a violation of the automatic stay. There are other remedies for parties to take to deal with who gets the car and how, but no longer will automatically it'll go back to the debtor without taking further action to demand turnover. So that's it for today. Stay safe. Thanks for watching.